Good afternoon, good morning, good evening, everyone, depending on where you're joining us from. I am Sara Pantuliano. I'm the Chief Executive at ODI. For those who don't know us, don't know ODI, we are a dynamic global think tank that aims to inspire people to act on injustice and inequality through collaborative research and ideas. I would like to welcome all of you to today's multilingual high-level dialogue, which will be in English with simultaneous translation into Russian. So for those of you who would like to listen in Russian, just select the relevant option on your Zoom menu. So this dialogue takes place in the context of the Global Week on Justice, and it really gives me great pleasure to have the privilege of chairing this event. The event is the public inauguration of the Working Group on Customary and Informal Justice and the SDG16+, of which ODI is a founding member. Now, you're all aware that more than 5 billion people live outside the protection of the law and are actually excluded from shaping it. And as a result, they're often denied their rights. They're marginalized, they're displaced from their land, they're subject to violence without remedy. And we know that an experience of injustice is very often a key conflict driver. So to try and tackle this global justice gap, the 2030 Agenda has committed all UN member states to ensure equal access to justice for all. And this is articulated in SDG16 on peaceful justice and inclusive societies. But if you really want to fulfill the promise of SDG16+, I think it is even more imperative that the global justice community engages effectively in customary and informal justice, or CIJ, as we'll be referring to it in the course of this webinar for short. And I think the case for engaging in these systems is very clear. The majority of justice seekers resolve their disputes over land, over water, over family relations, over all sorts of issues, and claim their rights outside of the formal justice systems. This is very often the first resort. And it's often also the only option they have, because for many people, CIJ systems prevail in regulating their access to land, water, natural resources, regulating family relations. So it is for these very reasons that the working group was founded last year. It was funded by a collective of justice stakeholders who felt very strongly that it was important to recognize the importance of better taking into account customary and informal systems. This has now become a global multi-stakeholder coalition of more than 60 organizations and individuals. That includes senior policymakers, activists, thought leaders, experts, all really invested in closing the global justice gap. The group has come together around a shared vision of a world in which all people have equal access to justice, but a justice that meets their needs. Of course, provided that systems are inclusive, are responsive, are effective, and are consistent with human rights norms and standards. So it is with this great vision in mind that the objective of the working group is to better understand the role of customary and informal justice, and then build the momentum towards a sustained right-based engagement with customary and informal justice actors. The aim of the working group really is to create an enabling policy environment for governments, for development partners, for civil society, so that they can engage effectively with customary and informal justice actors and try and build more inclusive justice systems. And importantly, I think the working group takes people's lived experience of how they access justice, how they seek protection and remedies as the starting point to consider the complexities of justice ecosystems, which are specific to each context's political history. The working group is actually really upfront about the challenges that are associated with customary and informal justice. They can be often socially conservative, can reinforce status quo power dynamics, they can violate human rights, and that is especially true for women, girls, and other marginalized groups. But rightly, the working group underlines that these criticisms are valid and potentially true for all justice providers, for the statutory, formal systems, and of course the customary and informal ones. What the working group has done so far is put together an action plan, and one that is leading to the second SDG summit in 2023, where the aim of the working group is to put CIJ at the center of the global justice agenda. The activities of the action plan really consist on building a network of the working group itself to include diverse stakeholders and actually to foster peer learning that then can, to lead to joint action. The group is also going to focus on research collaboration to try and strengthen the case for engaging with the reality of CIJ and identify the best ways to do so. And finally, the working group will engage in policy advocacy. The centerpiece of this advocacy will be a process of consultation, a process of dialogue that will result in a final report with key recommendations to be showcased at the SDG Summit in September 2023. So the reason why we have convened this dialogue today is because it is imperative to acknowledge the role that customary and informal justice systems plays in efforts to address the global justice gap. And I'm honored to be joined by 9 incredible speakers, amongst whom there are senior policymakers, justice providers, commentators, advocates, supporters, who will help us navigate the topic by sharing their experiences and perspectives. We will start by giving a virtual floor to the Honorable Manuel da Costa, Minister of Justice of Timor-Leste. Unfortunately, the minister is recovering from illness, so we will have Habib Mayar, the Deputy Secretary General of the G7 Plus Secretariat, reading his speech. We'll then be joined by Jamesina King, Sierra Leone Court of Appeal Judge and ICJ Commissioner. We are also with us is Sarah Hossain, Advocate and Supreme Court of the Supreme Court of Bangladesh and Honorary Executive Director of the Bangladesh Legal Aid and Services Trust. We also have Zamira Mamakeva, the Chairwoman of the Association of the Aksakal Courts and a member of the Aksakal Court in Bishkek. Zamira will speak in Russian, but there will be English translation available for those who are not following in Russian. We are also joined by Juan Carlos Botero, Associate Professor at the Pontificia Universidad Javeriana and former Executive Director at the World Justice Project. Also with us is Vicky Tali Corpuz, the Executive Director of the Tebba Foundation and former UN Special Rapporteur on the rights of Indigenous people. We'll then go to Atieno Odiambo, the Director of the Legal Empowerment Fund, the Global Fund for Human Rights. And I'm delighted there is also with us a co-member of the advisory group of the UN Peacebuilding Fund, Mariette Schurman, who is the Director of the Stabilization and Humanitarian Affairs at the Ministry of Foreign Affairs in the Netherlands. And last but not least, we will conclude our dialogue, giving the floor to Jan Beagle, the Director of IDLO, who will deliver some closing remarks. But let's get started. The discussion will focus today on 4 key areas. First, how we can better understand the full justice ecosystems in all contexts. Second, what can this customary and informal system deliver in terms of access to justice in ways that upholds human rights? And what are innovative examples of political and legal change processes that integrate customary justice and indigenous rights to enhance better access to justice? And finally, how can the global justice community better support engagement with CIJ actors to address the global justice gap? Before we get started, just to mention that I will be taking questions from the audience, so please do use the Q&A functionality that you can see on the Zoom chat, on the Zoom panel to raise questions for the panel. There is also a chat functionality, and I really encourage you to share ideas, resources, engage in the conversation with each other here. But also, let's take the conversation out there on Twitter. Please tweet, live tweet what you're hearing, what resonates with you, engage with the discussions on Twitter by using the hashtag SDG16+. But now, without further ado, I would like to give the floor to Habib Mayar, who will be speaking on behalf of Minister Manuel da Costa. Habib, the floor is with you.
Thank you, Ms. Chairman. This is an honor to read out the minister's statement, who had gratefully recorded his message, but due to connection problem, it could not be sent. This is what we call fragility, and this is what we live in, but it's an honor. The statement of Minister Manuel da Costa, Minister of Justice of Democratic Republic of Timor-Leste. Ms. Chairman, Excellency, ladies and gentlemen, it is an honor to be here today at this useful dialogue and share experience of Timor-Leste. Access to quick justice is an important pillar of lasting peace and stability in countries such as those in G7+. It's included in the Strategic Development Plan of Timor-Leste. Customary justice institutions have played a crucial role in Timor-Leste. The government is committed to work with community leaders and how best to attain the goal of access to justice for all. Timor-Leste is an independent and unitary sovereign democracy based on the rule of law, the will of the people, and respect for human dignity. The Constitution of Democratic Republic of Timor-Leste recognizes fundamental human rights, in particular those foreseen in international legal documents, establishes the general operating principles of rule of law, state, and the system of justice, and defines its institutions and their respective powers. The Section 2(4) of Constitution provides that the state shall recognize and value the norms and customs of Timor-Leste and are not contrary to the Constitution and to any legislation dealing specifically with customary law. However, no specific legislation dealing with customary law has been enacted. Traditional legal practices in Timor-Leste, usually imbued with ancestral religious beliefs, are inherent to systems in which kinship concepts regulate most aspects of everyday life. Conflict resolution and punishment of crimes are part of this. For Timorese customary practice are an integral part of everyday life and play a central role in resolving disputes between individuals and communities, such as land disputes, conflict between communities, and natural resource management. These practices focus on maintaining community and environmental harmony, in contrast to the formal justice system, which is perpetrator-focused. Ladies and gentlemen, to date, there is no comprehensive legislation regulating the informal justice sector in the proposal of law to regulate the customary law still in discussion. However, it is not entirely unregulated by Timorese law. Some existing laws have a bearing on legality and effect of local justice mechanisms. As mentioned above, the Constitution recognizes and values the norms and customs of Timorese that are not contrary with it. In July 2016, a new Suku law, law number 92016, was enacted. It addresses some of these deficiencies. It provides that duties of Sukus include to promote the solution to litigation occurring within the continuity of or between aldeas in Suku, chief Shefide Sukus, which means chief of Sukus, have the competency to intervene whenever requested in the mediation of conflicts or disputes between community members, as well as between the aldeas and the Suku nonetheless. However, Shefide Suku are also required to inform the police about facts which can constitute a crime. The most detailed legal framework relevant to the informal
I think we have lost Habib. Let's see if we can recover the audio quickly. Maybe we can just carry on and move to Jemsina, and then if we are able to reconnect with Habib, we can hear the second part of the speech. But I was actually really, I was taking notes of how well, Minister Da Costa was describing how integrated systems can work and sharing the experience of Timor-Leste in, so showing the effectiveness of how they can, really live together. So actually, I want to ask Jemsina about that, because that is also the case in Sierra Leone, isn't it? I mean, I think there are, the formal and CIJ systems are often thought to be in competition, but actually they can also be, quite well integrated. So Jemsina, can you share the experience from Sierra Leone? And then if you're able to, we go back to Habib.
Thank you very much. And I'm very pleased to be part of this discussion. Indeed, in Sierra Leone, we have the formal courts, and we have customary and informal systems, but primarily I want to focus on our local courts, because the local courts, they are in every chiefdom in the provinces, and they serve over 70% of the population. And so in order to have better cooperation and coherence between these customary justice systems, that's the local courts, and the formal justice system, in 2011, an act was passed called the Local Courts Act, which replaced the 1963 Act. And this act effectively brought the administration of these local courts directly under the judiciary, as envisaged by the 1991 Constitution. And this effort was also to address the justice gap, whilst recognizing the vital role local courts play in the delivery of justice. It was also part of reforms after our 11 years of conflict, with injustice being identified as one of the main drivers of the conflict. And so we had this change, and customary laws which applied in customary courts, the local courts, were reviewed to address issues of discrimination and violence and against women, and local court personnel and communities were trained on the rule of law and human rights. And with a lot of awareness raising, sensitization of procedures and systems in local and traditional courts, a lot has happened, and we now have the courts working together. There are challenges which I will refer to. Well, I want to highlight an area of violations affecting women, like rape. In the past, local courts would deal with it, but right now, there's a protocol. They cannot deal with issues like rape or very serious crimes. Immediately, these matters are brought to the local court, it is sent to the high court, or it is sent to the police. So while lawyers cannot appear for litigants in local court, you have customary law officers with legal background, and they advise local courts in matters of law and organization. They support research, and they assist in training of personnel in these courts. You also have paralegals who are also in these courts providing services to litigants. I must say that local courts are not in competition with formal courts, as their administration and jurisdiction are different, and they are clearly set out in the law. Their jurisdiction is limited only to the local area where they are located. They apply only customary laws that are not inconsistent with natural justice, equity, and good conscience, or any other statutory law. They do not deal with very serious criminal offenses, such as rape, as I had highlighted, and they only deal with certain civil actions clearly spelled out in this Local Court Act of 2011. They can impose fines or sentence to imprisonment within limits specified in the law. And so you ask yourself, what if they go out? If they go out of their judicial powers, it is an offense and they can be prosecuted. So the members of the local court, the chairman, vice chairman, and other members, they are appointed by the Chief Justice. So you see the link between them and the formal court. They are appointed by the Chief Justice in consultation with the Judicial and Legal Service Commission, and also advised by local court service committees. Their terms and conditions are defined by the Judicial and Legal Service Commission, and all the expenses of these local courts are covered from the consolidated fund. Local courts, they work closely with the formal courts. They provide monthly returns to the magistrate of the district, and the magistrate is from the formal courts. They can also, their proceedings can be reviewed by customary law officers when there's an allegation of miscarriage of justice or an error of law. But besides the review by a customary law officer, there are also appeals from local courts to the district appeal court, which consists of magistrates of the district sitting with 2 assessors. And then even from the magistrate's decision, there's an appeal to a local appeals division of the High Court, comprising of a High Court judge who sits with 2 assessors. So formal courts, when local customary matters are brought before it, they can stop these proceedings in the High Court or Magistrate Court and refer. So formal courts also refer matters to the local courts. So in effect, the High Court cannot deal with issues such as land that is governed by customary law, administration of estates of persons under customary law, as these fall within the jurisdiction of local courts. There are challenges as well in the local courts. They are not as well organized as the formal courts, and they lack the resources. They lack, because government does not provide enough resources for these courts to run effectively, and they need there's need for continuous training of the officials of this court. Currently, we have training ongoing by the judiciary of local personnel of these courts, supported by OSIWA, which is not government, but an independent organization. But I must say in closing that efforts towards coherence, cooperation, and alignment with formal courts have to be managed well, so that the procedures and practices of local courts do not lose that flexibility, accessibility, swiftness, community ownership, cultural and environmental relevance in providing remedies to citizens. And this is because the formal courts are overburdened with cases, and it is only recently that the judiciary succeeded to have resident high court judges in all districts of the country. There are also lots of delays in the formal system, leading to overcrowding of prisons, and litigation in formal courts are expensive. It's very expensive. To conclude, formal and customary and informal justice system can work very well together in achieving the common goal of providing justice for its citizens. They are not in competition, as they complement each other. Local courts are vital in closing that justice gap and increasing access to justice, particularly in the rural areas where it has its primary area of operation. Access to quality and inclusive justice through local courts is therefore crucial for sustaining peace, coming from a war-torn country, for sustaining development, as we are looking forward to having development, good governance, respect for human rights, and even for addressing poverty. Thank you very much.
Oh, thank you, Jemisia. That was such a clear account of how you can make really the best of this division of labor and having well-defined links and synergies between the two sides. I thought that added a lot of very tangible, knowledge of how it works in Sierra Leone, and I'm sure we'll hear in the rest of the discussion also in other contexts. Now, we've lost Habib. We can't recover the line with Timor-Leste. So I hope we can do in the course of the dialogue is to retrieve the speech from Mr. Da Costa and include it in the chat so that people can at least have a chance to finish reading his remarks. But let me go to Sarah Hossain. Sarah, Bangladesh has a very vibrant justice ecosystem. It goes from the formal justice system to the customary shalish, to active paralegals. Can you tell us a little bit of how civil society organizations, in particular in Bangladesh, have worked in collaboration with customary and informal justice systems, really to reinvent them in ways that can provide protection for human rights, for fairness, for equality? And I would also like to ask you to reflect on what you think this tells us in terms of the possibility of a productive engagement with the customary and informal justice.
Sure, thanks very much. I think I should speak a bit about the experience of shalish, the traditional or customary justice mechanism in Bangladesh, which has been present since pre-colonial times, which allows for informal dispute resolution in the community. It's interesting that it's common across many communities, irrespective of religion or ethnicity, although it has different names in different contexts. What's important about the shalish is it's a process that's held within the community and by community members. Of course, there are real issues in the sense that often the shalish traditionally is conducted by older men, often with very conservative views, not inclusive in any way at all. But even given that limitation, and very differently, I think, from my previous speaker, shalish is such, of course, not recognized explicitly by any kind of statute or formal law, but the process of informal dispute resolution, where the parties agree to the process and outcomes, where it doesn't contradict any recognized right or applicable law, for example, by imposing degrading punishments, is something that could be built on. And this was something that was recognized very early on in Bangladesh's history. So soon after our independence, out of conflict, out of a period of a liberation struggle following a genocide in 1971, in the early 70s, the first pioneering organization, a local grassroots organization run by a lawyer, a trained lawyer, who saw that the formal system was not something that was working for people. All of the obstructions of distance, cost, time, language, delay, implementation gaps. They reinvent, in that context, one organization, the Madaripur Legal Aid Association, reinvented shalish in two contexts. within the community and within civil society spaces. And this then became adopted by a whole host of civil society organizations. Bangladesh is tradition. So training mediators in applicable laws and available remedies, skills of documentation, and the process of mediation. And alongside providing a new avenue for justice, also ensuring that there were people in the community to inform about this process that was available through exactly the people we now know as paralegals. The results have been extraordinary. I mean, saving millions in terms of the costs involved in the process of seeking justice, and months and years of time in people's lives, and ensuring many of them safety and security in the process. It's also been interesting to see how these processes are adapted to technology more quickly sometimes than formal systems. We've seen how during COVID, we've had informal dispute resolution online through using low-tech systems, even like online mobile conference calls with 3 parties to try and resolve a dispute. We've also seen how these systems have adapted. Scholars are working on this now, looking at how, for example, WhatsApp messages, TikTok videos, Facebook messages are being used as evidence in community dispute resolution processes in a way that's not even possible in the formal courts. And these are coming up in family disputes and so on, and helping to, and being taken account of and facilitating solutions. So I think what's interesting about community dispute resolution in this restructured, reinvented format is its adaptability and its flexibility. So I think some of these progressive practices in Shalish can be very useful in the way we think about how we rethink the formal system as well, and how we make it more inclusive for women and particularly for vulnerable groups. In addition to this reinvention of Shalish, I think also looking at customary systems, particularly amongst Indigenous groups, has been another way for us to learn to think differently about our understanding of how to even further equality. For some Indigenous groups that have matrilineal communities, we've seen how their laws actually have enabled rights to be accessed, which are not available under statute or under other laws in our system. And what does this tell us about the possibility of engaging with community systems? What has our experience taught us? I think one of them is, of course, that we have to be aware, we have to be cautious, there have to be caveats in place. We need to understand ways in which community justice systems do and can restrict women's rights and the rights of the more powerless. But for a productive engagement, we have to take these issues firmly on board, not sideline them, not gloss them over, not deprioritize them, saying, cost and convenience are more important factors. Having taken that on board, I think we also need to think more critically about how courts can, in practice and reality, how they do, in fact, replicate the exclusions that we see in customary and community spaces, that they're not necessarily an idealistic alternative. Once we recognize that, then we need to look at what works and what doesn't. And remember that justice systems need to be open to all. I mean, if we look at the working papers that have come out of the group on customary and informal justice, we can see the vast numbers of people who are simply excluded from the system, the 5 billion who don't access justice at all. If you look at the formal system, we know that in Bangladesh, for example, 2% of women who experience violence even ever seek any kind of remedy. They can't get to the formal justice system. So they may not have perfect solutions in those situations through the informal system, but they can get there. And I think that point of access is absolutely critical for us to understand, that it's about opening a door, and then it's about refashioning what's inside the room. And I think we're in the process to do that. So finally, I think what we need to think about as we engage, and as we critically and productively and constructively engage, we have to be aware that formal and informal systems do interact, they do interconnect. Steps forward in one can enable forward movement in another. So it's not an either-or solution. It's not you have formal courts and that's where you invest everything, or you have customary systems, you do away with formal courts. We have to look at what those productive relationships are about and how we can make them work. And for that, I think working again in a holistic ecosystem, not only with lawyers, courts, and judges, police, and state mechanisms, but also critically with paralegal, with grassroots activists who are working directly with communities. That's the way in which we can move forward. Thank you.
Thank you so much, Sarah. That was really clear, and I couldn't agree more that it's really important to make sure that we work, very closely with, communities to really make sure that these systems are inclusive. With that, I'd like to go to Justice Mamakeva, and ask her, in Kyrgyzstan, how do you think ordinary and informal systems can, work together to ensure human rights in the administration of justice? a bit following from what Sarah was saying from Bangladesh.
Thank you very much for inviting me. It's a very good question. And let me tell you that in Kyrgyzstan, we do have justice, both formal administration of justice, and taking into consideration that it takes a lot of time. It's very difficult to administer justice due to the territory. We have an alternative form, and that is the courts of Aksakals, or courts of elders, and they play a very important role in administration of justice, and they deal with root causes, and a lot of representatives of in Kyrgyzstan. The law was signed, and now the number of Aksakal or elder courts, it's about 4,380 people are involved. It's the most accessible mechanism in order to settle disputes, some small domestic disputes, and also to settle disputes. It's very important that we do carry out prophylactic work and educational and awareness. Wise men, aksakals, or elders, they are able to resolve the issues, and that takes off the load, the burden of formal courts. That is why there are some advantages if we compare it to the formal system of justice. For instance, it is free for everyone. Also, there are no very strict or rigid procedures or proceedings, and we also have procedure of settlement disputes. We have a wide range of social regulating factors, and the law for us is the Constitution of Kyrgyz Republic, and it was granted for everyone. The citizens have the right to establish Aksakal or elder courts. And in our law, the Aksakal courts are mandated. It's a public body, it's a public authority, and they are independent. They also have the right to control the execution. Most of the courts have a lot of rights. So all family issues, all property issues, and also administrative responsibilities, civic cases. We also have a special service, and they have the right to oversee the execution of, and also they have the right to deal with to penalize people, to deal with different fines, and also to try to settle disputes between the sides. Social conflicts are very important to settle. Punishment is the very, very extreme rule for us. And what we are looking to do is to be able to settle disputes. In 10 days, the parties can appeal the decision of the elder court, Aksakal court. So our main job is to settle disputes, and we base our work on the custom law, and custom law does not contradict our formal law. And what we do, we always report our results to our founders, co-founders. We use mediation a lot, and it's very often we can differ from the state judges, because state judges have to base their resolution, their decision only on codified law. But we can settle the disputes. We try to use equity. We try to use our tradition of the people who live in Kyrgyzstan, but they should not contradict the law. We are trying to find justice, fairness, and we are trying to use evidence. It's very important with respect to human rights. When the courts cannot do anything with the parties, so we, based on the law, so we can help common citizens to find the truth, to find protection. So we do not compete. I would say that we supplement, we add to the state courts. And we think that in our research, in our National Research Institute, this is very important. The existence of alternate system is very important, and it is very positive. It has positive influence. That's my system, the system that I work in, and that's how we work, our Aksakal or our elder courts. Thank you.
Thank you so much, Zamira. Again, some really tangible examples of how the customer and informal system integrates and reinforces the formal, and actually how they reinforce each other, and they sort of mutually supportive. And I think that is coming out really strongly from this discussion. I'm sure we'll hear even more reinforcement from Juan Carlos, because actually, sorry, go ahead. Did you want to add something, Zamira?
I just wanted to add that we very, very closely interact with our law enforcement and our formal courts, and we help to get our elders, our Aksakals involved in carrying out of justice. We have a new constitution quite recently, and what we did in the new constitution, we actually introduced funding, because they all were volunteers, but now with new law that is mandated by the constitution, I guess that our life will be easier. We are going to get funding. Thank you very much.
No, that's really great to hear. And I was saying we can, now go to the experience of Latin America, that I think, is with Juan Carlos, I come to you to hear more, because Latin America has actually been, a bit at the forefront of some really innovative legal and political developments, with customary justice and indigenous rights being negotiated into constitutional texts and new political arrangements. But actually also to align with human rights and gender equality principles. So can you add to the richness of the details that we've been hearing so far, from Sierra Leone, Kyrgyzstan, Bangladesh, and Timor-Leste?
For Sarah, thank you first for having me, and thank you for the previous speakers for this very interesting dialogue. First, as a matter of context, when you think on, for instance, Malawi, they have like 24 judges and 10,000 chiefs. So justice is basically the informal customary system. That's justice in the land, except for the small minority. If you think on Liberia, they have like 100 judges and thousands of chiefs. So the same is, that's not the case in Latin America. When you think in Latin America, the ethnic divide between mestizo and indigenous population after 500 years of European conquest is a minority of the population. In Bolivia, maybe 20, 30%, but it is mostly 2, 3, 4% throughout Latin America. So we are dealing with minority rights. And in terms of the constitutional recognition of these rights, there's different models. For instance, just to mention 3, in Argentina, where there's only 2% of indigenous populations, they have adopted what we'll call a multicultural model of recognition. In Colombia, where you have between 10% of minorities between indigenous and Afro-Colombians, you have a pluricultural model. And in Bolivia, where indigenous communities are a very significant part of the population, you have a plurinational model. Now, what does this difference mean? This difference means different degrees in which the system recognizes the autonomy of the indigenous communities in dealing with their own issues. And so it's a matter both of jurisdiction and it's also a matter of applicable law. Now, very briefly, moving to what does the taxonomy mean from the point of view of the indigenous communities? So when you look at it from the, let's say, Western perspective or a majoritarian view perspective in the population, which we basically have a civil law system in most countries in Latin America, few Jamaica have common law systems, but basically it's a civil law system. Indigenous communities have a special jurisdiction where they resolve their disputes. But most disputes go eventually to the Supreme Court, and the system is integrated, unified through the Western dispute resolution mechanisms. When you see it from the point of view of the indigenous communities themselves, though, the situation is different, because what they perceive is that the system, although it recognizes their autonomy, when the test comes to happen, the understanding of a Western definition of human rights is imposed on them. Very much in the same way that for instance, in the context of Liberia, the chiefs apply sassywood, which is a trial by ordeal. It's a poison that, a concoction that people have to drink. And this is perceived as unacceptable from the point of view of the Western understanding of human rights. For them, it's a millenary tradition, which is also present, of course, in Sierra Leone and many other countries in Sub-Saharan Africa. We have, in Colombia alone, we have more than 100 different indigenous communities, and each one of them have different customary system of dispute resolution. Of course, they group in different ways, and we could have a taxonomy of 5 or 6 different categories of dispute resolution among them. But at the end of the day, the question becomes, how do we, to what level do we integrate the Western understanding or the global understanding, depends on where you stand from, of human rights, based on the Universal Declaration, for instance, and SDG16, with their own cultural understanding of that, and to what extent this cultural understanding is an excuse to simply perpetrate patterns of male dominance and practices that may not be aligned with a more global understanding of justice. This challenge has, as I mentioned, 120 different colors in each one of the countries. The constitutional recognition and the dialogue, to conclude, is not a one step, but it's a moving forward, case by case, in which you start to adapt to a point where mutual understanding and recognition becomes a fair ground of acceptance, mutual acceptance among different groups. That I conclude.
Thank you so much, Carlos. That was really such an important point, because it's at the heart of the challenge, how we really try and reconcile, as you put it, how these cultural understandings of indigenous communities can coexist with global understanding of justice, pretty much rooted in Western culture and history. And I think I want to come to Vicky on that, because Vicky, you've obviously been the UN Special Rapporteur on the rights of indigenous people. So it'd be useful to hear your reflections on what role is there for indigenous justice, in achieving access to justice for all, and how, these tensions that Juan Carlos was also highlighting can be better addressed. You're on mute, Vicky. Can you please unmute?
Okay, so thank you very much. And I'd like to thank the ODI for organizing this event, because many of the things that I have heard so far resonate with the thinking and the experiences that I have seen, both in my role, of course, as an indigenous activist, but also when I did my mandate as the UN Special Rapporteur. You may know that one of the key demands of indigenous peoples when we were negotiating the UN Declaration on the Rights of Indigenous Peoples is the right of indigenous peoples to use their own governance systems and justice systems. So Article 4 of the Declaration has stated clearly that indigenous peoples have the right to use their own legal, economic, and political institutions, and Article 34 says that indigenous peoples have the right to develop and strengthen their own institutions, which includes the justice systems if these apply, and it should be in accordance with international human rights law. So clearly, when we were negotiating the declaration, it was always clear in our minds that the our own justice systems should not be in violation of international human rights law, because there is this belief, right? There's like the dominant thinking in many societies that indigenous peoples are, their systems are backward. These are not in accordance with justice or human rights. And we dispute that. We say that actually many of the justice systems that we have, and most of the issues, the disputes in our communities are actually settled by indigenous justice systems. And I've seen this everywhere I go, in Ecuador, even in Bolivia, that there are indigenous justice systems and there are justice authorities who are well respected by the indigenous peoples themselves. And the extent, of course, into which these are integrated into the formal system, this varies from country to country. In my country, in the Philippines, this is one issue also that we have fought long for. And in 1997, finally, an Indigenous Peoples' Rights Act came into being. And one of the articles of that act does recognize the use and the practice of indigenous peoples of their own customary laws and justice systems. No, and I think this is something that is a major improvement, no, from where we were maybe 20 years ago, no, and now even the ICJ says that 80 to 90% of disputes especially in fragile and conflict-ridden communities, 80 to 90% of these cases are settled by customary justice systems. No, it's not the modern justice system that does that. And this is true even in our case in the Philippines, where we of course have a modern justice system. It's very difficult to access this system. No. Which of course is because of the expenses that are entailed. You have to hire lawyers, but also because of the language. No, interpretation is a very basic issue, and in fact, many of the cases that have been heard in the Philippines with regards indigenous peoples is the fact that the courts cannot translate, into the language of indigenous peoples who don't speak any other language than their own. No, and of course, how can you access justice if that's the case in many countries? And that has been the case in many countries. No, formal justice systems, of course, have this all written either in the dominant language. In the Philippines, it's English, not even in the national language. No, so that in itself is a big issue in the question of access to justice, and that's what indigenous peoples have been fighting for. That's why when I talk to the indigenous justice authorities, one of the things that they are demanding is that indeed they have the right. I mean, because there are cases that they cannot settle, and they would pass this on to the justice system, but they would ask that interpretation should be provided, no, both to the ones who have filed the cases, as well as, of course, the justices. No, and I spoke to the Supreme Court justices, for instance, in Ecuador, and they are very much agree with that. They said that indeed, I mean, if we don't understand the cultural context of these people in their languages, we cannot really do anything about the cases that are being brought to our attention. So I think those are just few of the issues that I've seen. I'm running out of time, but if there are some questions later on, I can also deal with this. Just to say that indigenous justice systems are vibrant, the customary laws are living laws, and this is what brings a better peace and security amongst indigenous peoples in many parts of the world. Thank you.
Thank you so much, Vicky. That was really powerful. I think the relevance of these customary and informal, justice systems to communities, to their lived experience, to the cultural context is coming out really strongly from the discussion. And I actually have seen quite a few comments in the chat, also stressing what all of you are saying about the importance of these long-standing informal justice mechanisms, how many of them are pre-colonial, how they've actually demonstrated resilience and relevance throughout the pandemic. All really important point. I encourage you to read, because they really complement well the discussions we are having. And just to add that the speech from Minister Da Costa has also been added to the chat. Atino, let me come to you. We've heard so much that really makes such a strong case for taking better account of customary and informal justice. So how can the global justice community work better, take better account of CIJ to deliver on SDG 16.3? We can't hear you, Atiel, I'm afraid. I don't know if it's the headphones. Or... You're not muted, but your voice is not coming through.
Can you hear me now? Okay, thank you. Yeah, thank you very much, Sarah. Indeed, it's an honor to share my thoughts on customary and informal justice at this event. And actually, much of what I was going to say has been articulated by the previous speakers, so I'm merely reiterating some of the points that they have made. You know, customary and informal justice mechanisms hold great promise in enhanced access to justice, and the global justice community can better take account of and with CIJ by ensuring that formal legal systems and CIJ mechanisms can interact in a manner that is mutually reinforcing and focused on an effective system of justice. Of course, I say this with the recognition that the area of CIJ is a dynamic and difficult terrain that's, you know, replete with competing approaches, different conceptions of justice, and different levels of operation. However, as has been said before, the reality is that in most countries in the global south, people use both formal and customary informal justice mechanisms. And these systems don't operate in isolation, and they're therefore bound to influence each other, both in terms of process and outcomes. So the global justice community should recognize the relevance of CIJ for the following reasons. For example, you know, CIJ reflects the lived realities of communities, and it increases access to justice for most of them. CIJ is also a framework for expanding human rights and human autonomy. And this is because as a lived reality, it changes and adapts to new circumstances. It can respond to legal changes and therefore adapts to human rights norms. CIJ mechanisms are also a really important site for guaranteeing human rights by providing an easier and much more affordable, more approachable, and really importantly, culturally and socially appropriate forums for individuals to access justice. CIJ is also a mode for doing justice differently and more effectively, and it accomplishes this in, you know, a myriad of different ways. First and foremost, it's not adversarial; it's a form of restorative justice, and, you know, restorative justice which focuses really on rehabilitating offenders through conciliation with victims and the community at large. The idea being that for justice to be served in a community, it must aid members of the society to rely on each other. It also ensures a more social inclusion since it's more participatory, you know, unlike formal court systems. CIJ mechanisms focus on maintaining social inclusion, which really brings about cohesion. And really importantly, CIJ mechanisms are more affordable because they are closely tied to the communities and are mostly institutionalized. They're also very expeditious and are less adversarial and incorporate more creative remedies. Really, they are not a legal contest, but really are part of a system of harmonious living. Of course, you know, there are lots of critiques about CIJ. And, you know, unlike CIJ, like most dispute resolution processes do have challenges, but however, because they are based on lived experiences, you know, CIJ allows for the development of alternative approaches and interpretations that will open space for challenges to cultural beliefs. So challenges to CIJ can, you know, be mitigated, for example, by engaging CIJ through a robust human rights framework, which really goes without saying that a human rights framework is, you know, essential for the success of CIJ, and it really brings about a balance between civic autonomy as well as human rights values. And also where there have been allegations of human rights violations within CIJ mechanisms, there do exist the formal justice mechanisms and other state organs that can provide checks and balances and provide remedies for these violations. You know, I'll give an example, you know, in Kenya where, you know, we're just, you know, starting off with this alternative justice system mechanisms, and, you know, where the wheels of justice within the formal system moved very slowly. And the drafters of Kenya's new constitution, well, I call it new even though it was promulgated in 2010, but it's still new in my books, recognized the really important role of CIJ and revived the prominent place of African customary law and traditional systems of justice through Article 159(2)(c). And this article gives the judiciary the mandate to promote traditional methods of dispute resolution, but at the same time subjecting those mechanisms to a human rights framework of the Bill of Rights. And 6 years later, the judiciary of Kenya, under the then Chief Justice of the Supreme Court, Willy Mutunga, incorporated alternative justice mechanisms as a core strategy to deliver access to justice to Kenyans. And at that time, I was working for the then Chief Justice, and an interesting aspect of the work that we were doing at the judiciary was, on the one hand, we were working towards making sure that alternative justice mechanisms were part and parcel and were recognized by the judiciary and promoted by the judiciary. On the other hand, Kenya has 47 counties, and the Chief Justice, always said, I'm building all these courts in, and his mandate was to make sure that there was a high court in every single county. And he would say, I'm building all these courts, but the reality of it is that most Kenyans resolve their disputes in informal systems and use alternative justice mechanisms. So, to that extent, I'm running out of time, but it really is important to see that that both systems work in tandem, and all the speakers have really reiterated that. Thank you very much, Sarah.
Thanks, Tatiana, but you've added another layer of clarity to how actually we can really work to get the two systems to interact better. Thank you. I thought that was really, really powerful. One set of players we haven't talked about yet is development actors. So I'll come to Margaret to reflect on that, because surely there is a role they can play, or maybe that they shouldn't play. But what can development partners do? What are they doing, or what they can do differently to approach the entire justice ecosystems and support CIJs as well as the formal justice system to deliver on SDG 16.3?
Thank you, Sarah. And it's a pleasure to be here. So from a development actor's perspective, what are we doing and what should we do more or differently? So what are we doing? As we know, even before the pandemic, as everybody here knows, that 1.5 billion people across the world didn't see their justice needs fulfilled. And since then, since the pandemic, that number has only grown. So the Netherlands has been a very strong promoter of people-centered justice, where people's justice needs are the starting point for finding solutions. And taking that people-centered approach forces us to do, first of all, find solutions that are evidence-based and data-driven, so to better understand where the different justice needs are. So for instance, Hill, through his research, has helped us to identify that in Tunisia, employment-related disputes are among the most prevailing legal problems, whereas in Mali, people have most disputes around land. And solutions also need to be found beyond the formal justice systems. Obviously, informal justice can play a very important role. Even in the Netherlands, only 4% of legal problems is addressed in courts. So often informal and customary justice is more accessible and trusted than the formal systems, and we've learned many examples. Examples that we have supported is, for instance, paralegals in remote areas in Mali that provide legal advice and dispute resolutions with local leaders. And in Somalia, with our partners UNDP and IDLO, we're working to bridge the gap between the formal institutions and alternative dispute resolution close to communities. So what should we do more or differently? I think first, we need to become better at looking at justice ecosystems as a whole and to listen better to what people really need. So systems, and today again demonstrates that they're very context specific. There's often a lack of understanding amongst international players and actors about the nature of informal justice systems, relations with the formal systems and their impact and constraints. Secondly, we have to better monitor human rights compliance and equal access and treatment by informal and customary justice mechanisms, particularly for women, youth, and minorities. Already we explicitly request partners working in countries with traditional or informal justice systems to respect international agreements on human rights when they are delivering programs supported by the Netherlands. And this is also under scrutiny by our parliament. And the third thing we have to do better is coordinate better and scale successful approaches that work. Because collectively we can obtain a better understanding of the potential of informal systems to significantly increase access to justice for all, to build on local mechanisms that are already in place and scale interventions that work. So we're very happy with this working group that you initiated, Sarah, on customary and informal justice. We will also be taking this subject forward as a work stream in the Justice Action Coalition that we initiated. That's a coalition launched by G7+, the Elders, and the Center for International Cooperation, with the aim to advance people-centered justice. And we think that today and further meetings really can help to align our actions and initiatives, to exchange ideas and to learn from each other, so that we indeed can scale up our efforts and fill that gap of justice needs, which is still vast and enormous. Thank you, Sarah.
Thank you, Mariette. And yes, let's definitely make sure that this dialogue continues, across this multitude of actors, because I think we're going to make progress if we work across, if you want, silos or traditional areas of engagement, because we really need the efforts of everyone to close the global justice gap. This has been an incredibly fantastic first round of interventions. Mariette, I know you need to leave us in about 10 minutes, but we do have about 25 minutes to open to the Q&A, and there are already a lot of questions that have come in. So I'll start with some of the questions in the Q&A. There are others in the chat. I probably won't be able to take all of them, but let's see how many. If you brief in your replies, we can try and bring in all the questions that have been put. So I'll come with the first one to Justice King. It's both for Justice King or Ms. Hossain, but maybe let's start with Justice King, and then Sarah, if you want to add anything, please do. As CIJ systems tend towards conservatism and reinforcement of patriarchal power relations in many contexts, what are some of the ways we've seen women empowered to engage with and demand equality and accountability from CIJ providers? Are there any insights or practices that might be transferable? We've touched a little bit on this. Maybe we can add a little bit more, but briefly, please, so that I can get to other questions.
Thank you, Sarah. I think that raising awareness about people's rights, empowering women to understand their rights, and also with the parliament, because for us in Sierra Leone, indeed, we have a patriarchal system and women have been discriminated for quite a long time. But immediately following the war, women occupied spaces to advocate for changes in the law. And we've had changes in the law in respect of, we had for the first time a domestic violence law. We had changes in the law in relation to customary marriages and divorces, recognizing them. But it was actually the parliament passing laws overriding discriminatory customary laws and practices and creating offenses for those who would still want to go back to discriminatory customary laws and practices. But it is important that women know about the laws. It is important that also these personnel manning local courts are also aware of these laws. And it's also a question of the country having a commitment to make that change, to ensure that the rights of women are respected and protected. So I think there's been so many legal changes in the law, and that has helped to create that awareness and respect for women's rights in the system. Thank you.
Thanks, Jamesina. Sarah, there are other questions, so maybe I'll come to you with some other questions, and then integrate also an answer to this. But I just want to use the time to get to as many questions as possible. Zamira, there's a question for you. What challenges have women faced in asserting their leadership in Kyrgyzstan's Aksakal system? Are there lessons that can be drawn from the experience of Kyrgyz women as justice dispensing elders that might be applicable elsewhere? give it a minute for the translation to come through.
Да, слышу.
Да, вопрос.
У нас судья Аксакалов тоже избирают и женщиной.
Yes, our Aksakal courts actually have women represented, and it was back in 2013. A concept of gender equality was introduced, and since that time, a number of women are appointed as members of the Aksakal courts, and therefore, because the number of issues can be resolved essentially by only by women, and they are much deeper involved in certain aspects of the cases brought to the attention by Aksakal courts. And sometimes women even elected to be chairs of such Aksakal courts. And some people even are very much surprised how in traditional society a woman can be a chair of the court or supreme justice of the Aksakal court. Because normally the traditional understanding of what the chair must be, it's an old male with a long white beard. But the Aksakal means in our language the elder, an old and experienced person. And but women normally have a better understanding of certain issues, especially when the women are involved as claimants and defenders, and particularly in family relationship. So the predominant mentality of the local community is such that women normally are more willingly talk to women and are reluctant to share their problems with the male Aksakals. So, and primarily the women for Aksakal courts are recruited from the urban population as well as from the rural areas.
Thank you very much, Zamira. In the 2 minutes before you're going to leave, Margaret, just one question that I think would be good for you to address from Lisa Denny, who asks, given the relevance and the value of CIJ, how can we raise its profile and motivate the global justice community, and I would add also the development community, to pay greater attention to CIJ, not just as an afterthought to formal systems?
It's a very valid point, but I think, it is all about impact. As I said, the justice gap is so enormous that we have to do better if we are serious about delivering on SDG 16.3. And then I think there's a bit of a risk that we may see customary and informal justice as a silver bullet. Or bullet is the wrong word in this context, but anyhow, you get what I mean. Because there's also many ifs, I think, and they've been highlighted as well. But given the fact that informal and customary systems is really the main channel for people to, the opportunity they have, if we fix it right and support it in the right way and by well understanding the system and the interactions with the formal system, I think that's it's the most important and powerful tool, I think, that we have to deliver on access to justice for all. So we just have to increase the sense of urgency, I would say.
Sorry, it was me. Yes, absolutely. Thanks, Marita. Thanks for squeezing this in, just before you need to go. Sarah, I wanted to come back to you with what is a really long question in the chat, but I'll just read the final bit, asking, how, if panelists can give examples as to how they've challenged discriminatory practices and/or institutions, and then, of course, do reflect on the previous question as well.
Thanks, Sarah. So I think, let me reflect on the previous question. Actually, I just kind of wrote an answer to that. But I think some of the ways are to engage in two levels, to engage on the kind of supply side, if you like, the process of providing justice solutions. So that means in terms of the community justice systems, one is trying to redress the power imbalances there. So ensuring that the decision makers or the arbitrators or those doing dispute resolution are from a more diverse group. Our practices have been to try and ensure, firstly, of course, that women are part of that group, but also the very interesting innovations happening by a number of organizations in Bangladesh to ensure that people from marginalized groups are there. So in BLAST, for example, we work with many Hijra communities, and there are now paralegals within those Hijra communities who are themselves trained to provide legal advice and support, and in some cases to take part in dispute resolution as well. I think the other aspect that's very important, though, if community systems are going to be accountable, is that people have to be able to know how they operate, see how they operate, and call them out when there are problems created, because we're very aware of the kinds of problems that can happen. So I wanted to give an example that we had in Bangladesh where community systems which ran riot in terms of imposing so-called fatwas and imposing degrading punishments on women and on men, but mostly on women, were ultimately questioned by the Supreme Court and questioned on the basis of invoking, constitutional standards around freedom from cruel and degrading treatment, equal protection, gender equality, and so on. So I think we have to be aware of the fact that, we are, most of us, operating within constitutions that guarantee fundamental rights, and equality is an absolutely basic fundamental, gender equality in particular, that there are international standards in play. I think we can't push those to one side. So I think the advocacy and the engagement around re-invoking what that framework is, while working inside the system to also increase representation and diversity within the community processes. And I think holding them to the point that they also have to evolve, that they can't be stuck in wherever they are. They have to evolve within this framework of plurality, but also within a framework of equality. I think those have been some of the approaches that have been useful.
Thank you very much, Sarah. And just so that the question in the chat was from Gita Sagal. Thanks, Gita. There's another question in the Q&A from Martin Grammatikov, and maybe Atieno, I'll ask you to address this one. For obvious reasons, informal and customary justice is significantly more popular and trusted in rural communities. Do you see functional substitutes of informal and customary justice in urban settings?
Thank you for that question. Yes, actually, within the Kenyan context, a lot of a survey had been done on looking at alternative justice mechanisms, and they did find that even within urban settings, especially in informal urban settings, the customary and informal justice mechanisms are used there. So again, within the context of Kenya, you find that each region, each ward does have a chief, and these chiefs are the ones that people go to get disputes resolved. So it is actually a very functional system of justice within urban settings. It's not predominantly in the rural areas. And you actually have other systems that there's one called the Nyumba Kumi. This is whereby different neighbors get together and hold each other accountable and look out for each other. And within those systems themselves, when disputes do arise, they're resolved within those conclaves. So I think for sure within informal settlements and in areas that are where marginalized people live in, you also have churches and other religious institutions that are resolving disputes within these settings. So yes, there are functional disputes, and some are even actually formally recognized by the court systems.
Thank you so much, Atieno. Vicky, I'll come to you for the next question. So the question says, I wonder if any of the panelists have observed cases where the customary justice systems or leaders have been responsible for delivering other types of community services, for instance, services that go beyond the focus on dispute resolutions. And perhaps you can address that by sort of thinking of indigenous governance actors.
Yeah, well, yes, I'll answer that. But maybe before I go there, I just wanted to add to the question about how we are dealing with some practices which might be in conflict with international human rights law. And I just wanted to mention that one of the ways we would do is to really organize the people themselves, the women. In our case, we organize the women in our communities. And they were the ones who changed some of the customary laws which are discriminatory to them. Like, for instance, bride price. There is a practice of paying for to get a bride, and dowry, the payment of dowry. And the women whom we organized were the ones who actually changed the customary law and challenged the justice authorities that this cannot prevail. So I think a key step should be to organize these people so that they will know what their human rights are and demand changes in their own customary systems when they see that these are not protecting them. Well, the other roles that justice authorities do in communities, in several cases in Latin America, they are also the governance authorities. Usually they're also the ones who are running the autonomous government. And so they have dual roles. But in other indigenous communities, of course, they are, as was mentioned by somebody earlier, the mediation and conflict transformation work is also done by them. They go out of their way to really bring the conflicting parties together. In our case, we have peace pact holders who are the ones who are also justice authorities, but they are the ones who forge peace pacts with the neighboring tribes whenever there are conflicts that emerge. So I just wanted to mention that. And I have to say goodbye as well because I have to run to another meeting.
Thank you so much, Vicky, for being with us and for all your incredibly powerful contributions. We've got just about 7 minutes. I'll see if I can sort of squeeze in another 2 questions. Juan, I'll come to you with the next one. Are there any negative effects linked to recognizing CIJ in a constitution? And can you provide any example?
Sure, there are. It is good that they are recognized. It's much better that they are recognized than that they are not. But there are risks as well. One of the risks is that they can dilute and annul the system by itself. And it comes from the fundamental misunderstanding of what the system is. The customary justice system among many communities, the dividing line between justice and healing is blurred. The elder, the person that knows, is both the person that heals disputes in the community, but also heals physically, like the medicine man sometimes. In Colombia, some indigenous communities are like that. And among the Kogi Indians, for instance, they called us, let's say the Western type of persons in the country, the little brothers, because we do not know. They know better. And to some extent, you speak with them and they do know better about many things, about the way the planet is working. So the recognition that our, let's say, the international system also doesn't work, that we have a justice gap of 500 million, half the population of the world does not have full access to justice. And the degree of recognition in the Constitution, to the extent that it acknowledges something as weird and other, there is a risk of annulling it. And that may happen with the multicultural paradigm, accepting, and this again moves case by case, that the interaction and the different cultures speak to each other is a case-by-case adaptation that's a lot more complicated. So it depends a lot on how you adapt it to the Constitution. And of course, we could speak 10 hours on that, but we don't have time, so I'll stop there.
We could go on all day, but I saw that Athena was also typing some comments on this. And Athena, I'll ask you to also perhaps address The other question is in the chat, which is what could be some of the ways to scale the practices of community providers? How can standardized tools be created without losing the diversity of local practices? Sarah is also typing an answer to that. And I think that would be the last question. So I want to make sure that we have some time for Jan to share her final remarks. Robert, I saw you just added some comments, and if any of the speakers want to address that in writing, that would be great. But Atieno and Sarah, since you were already typing answers, please share your answers, and then I'm afraid that will be all we'll have time to for the debate.
Sorry, should I speak, Sarah?
Whether Atieno go first or Sarah go first? You were already typing answers to the question.
I'll keep typing. Let Atieno speak.
Okay.
I was actually going to suggest that Sarah go first because I was actually not typing, but let me see if I can answer this question. I think one of the things that, some of the standardized tools, and this is something that, the Kenyan Constitution does say is that, that the recognition of traditional dispute resolution mechanisms should be embraced, but then have to remain within the ambit of the Bill of Rights and as long as they're not repugnant, for example, to human rights norms. So I would say that the standardized tools should be what are the human rights norms that that we all adhere to, and then continue to use those even within the cultural context and within the local practice context. But I think for me the constant north has always been and will continue to be the international human rights norms.
Thanks, Atieno. Sarah?
Yeah, I want to completely wholeheartedly agree with that. And just in terms of scaling, I think there has to be some caution because it's really important that if we are going to respect those norms, that there has to be understanding of those norms by those who are part of the process of scaling. And I think it's risky for us to just say, scale it up, it's cheap, it's fast, it's effective. We need to be more thoughtful about it. And I think the one way to do that is to put the investment into engaging with communities. And I think this point that Robert is making is really interesting, that look at what are the positive aspects within our court system. So not just go straight down to the ground to everything in the community, but look at what are the processes for informal resolution within court systems, within, for example, city. I was going to put in an idea that's being generated here at the moment, that how do you use cities and municipalities to do dispute resolution within their own processes. So looking at how you build that, I think, into formal structures could be another way to go, rather than over-romanticizing, I think, only the community.
What a rich and insightful discussion. Thank you, everyone. Jan, I don't know how you're going to bring this all together, but really over to you for your reflections and closing remarks. I'm sure you agree that this has been incredibly fulfilling.
Well, thank you very much, Sarah. And as we bring this event to a close, first of all, let me first extend a warm thanks to you as our chair and to ODI for hosting this very timely and rich discussion. Today, we celebrated the public debut of the working group and launched its ambitious joint action plan. This plan really does, I think, offer us a comprehensive roadmap to guide future support to customary and informal justice systems and to close the SDG16+ implementation gap in the lead up to the 2023 summit. And across today's discussions, I think we heard a very common message, both from the panel and from all of those who intervened in the chat. And that message, repeated again and again, was that access to justice for all and SDG16 cannot be achieved without effective and strengthened engagement with customary and informal systems. And I think this is why the mandate of the working group is absolutely crucial. And IDLO is pleased to be a member of this really important initiative. For over a decade now, I would say that IDLO has been a pioneer, perhaps, in research and programming on customary and informal justice. And our dedication to this issue is founded on a simple fact, that we cannot achieve the goal of justice for all by 2030 without making customary and informal systems part of the solution. And I'll just allow me to share briefly 3 insights from our experience on why this initiative is so important. And I believe that our experience has really been borne out by what we've heard today. First, realizing equal access to justice for all requires engaging with the systems that most people, and especially the poorest and most excluded groups, already turn to. So, as we know, customary and informal justice systems enjoy high levels of use and acceptance in the communities where they're rooted. And in order to reach the targets of SDG16, all justice stakeholders need to recognize the legitimacy of these systems and integrate them into broader efforts to achieve justice for all. Secondly, engaging strategically with customary and informal justice systems is essential to ensure greater respect for human rights, because we know that in some contexts, these systems can perpetuate structured discrimination, unequal power relations, or harmful practices, particularly with respect to women and girls. So linking these systems to formal justice systems, and in particular providing capacity building and other support, can help to protect the rights and interests of marginalized and vulnerable groups. And this brings me to my third point. We need to pay particular attention to the rights of women and girls in customary and informal systems if we are to make progress on SDG 5. Some of the most common justice issues that women face, inheritance and property disputes, gender-based violence, among others, are resolved or adjudicated through informal systems, and they must be gender responsive. So in conclusion, IDLO is a proud member of the global coalition working towards a more people-centered approach to justice. We believe we have a unique opportunity now to reimagine and redesign justice systems that are grounded in a better understanding of people's justice needs. And I heard someone today say we need to listen better, and I would really agree with that. But we need a better understanding of the needs and of the diverse pathways by which people seek to resolve disputes. And as we've heard today, engaging with customary and informal justice systems is clearly an essential part of this effort. I think it's great to see the level of enthusiasm and energy here today. And IDLO is committed to working with you through our programs, our research, and our policy advocacy to achieve our shared objective of ensuring access to justice for all. And I thank you very much, Sarah, and thanks to all of the panelists and everyone who has participated in this really, really interesting discussion. Thank you.
Thank you so much, John. And really thank you to IDLO for all the work you've done and you continue to do to put, customary and informal justice at the center of, these efforts of the global justice agenda. So we all have a sort of a debt of gratitude for your efforts that you continue to push, and in many ways for also, the energy that you're putting behind the working group. And I want to thank all those who have joined the discussion today. Of course, all the panelists, but also everyone who has attended, has put questions, comments in the chat. It really shows how vibrant this community is. Advancing human rights, justice, and inclusivity is also at the heart of ODI's new 5-year strategy, which we launched earlier this year. So we're really honored to be part of the working group and to be part of a sort of hosting this very important and timely dialogue today. So I hope that all of you will continue to support the working group, to engage in the working group, and really, help the working group as it seeks to broaden the ways people-centered justice is pursued and ensure that it really takes the lived experience of people around the world as its starting point. So I encourage all of you to look at the working group's webpage. I hope someone will put it in the chat and join its membership so that we can amplify our efforts. But thank you once again to all our incredible speakers and to all of you for joining today. And we have 2 years of work to do before we can get to the appointment in September 2023 for Agenda 2030. But with that, really big thank you, and hope there's a good progression for the rest of your week. Thanks, everyone.